criminal administrative action means warning, it includes reprimand. There are no punitive sanctions. It includes counseling and advisories. That is not the kind of punishment that is expected for persons who have embezzled public funds through violation of procurement laws and regulations. So the proposal in that bill to substitute criminal sanctions with administrative action for procurement-related corruption are retrogressive, and they will take us backwards in the fight against corruption.
Do you have an idea of what could be inspiring the action at the Senate?
Certainly, I cannot read their minds, but we are going to engage them with a view to having them reverse that process. And you need to distinguish the two. These are different bills. The first bill is the Conflict of Interest Bill, which is a good law. It was intended to strengthen the fight against corruption. But amendments were introduced in that bill, weakening it and diluting it. So as the Parliament finalizes enactment of that law, we want them to remove these amendments that were introduced and weakened the initial bill. The initial bill is a cabinet bill that was tabled before the National Assembly by the majority leader, and because it concerns counties, it was also tabled before the Senate by the majority leader in that house. But when it went there, instead of being considered in a manner that enables realization of its objectives, some legislators saw an opportunity to incorporate provisions that negate the very essence of having the bill or that law in the first place. For example, initially the bill proposed that government officers be completely prohibited from trading with the government. They deleted that provision, meaning that in essence, government officers should actually trade with the government. They also interfered with the existing law because currently we have a provision, the current law has a provision under Section 42 of the Anti-Corruption and Economic Crimes Act. The current law has a provision that makes it criminal for one to engage in conflict of interest. That is where the current governors in court have actually been charged. The offense with which most of the governors are in court are charged is based on that provision that is sought to be deleted. So if that provision that makes conflict of interest criminal is deleted from the law, then it gives everyone a free pass, together with their families, their spouses, children, and the siblings, to be the ones doing contracts in the county governments. It will be the governor, the wife, or the husband, as the case may be, their children, and the relatives who will be doing all the contracts without sanctions if that bill becomes law. So we are urging the National Assembly to review the bill, remove those retrogressive provisions, and pass the initial bill approved by the Cabinet. In this area, Tharaka Nithi, the Commission is investigating various cases of embezzlement of public funds. We have about 18 cases of corruption that are under investigation relating to Tharaka Nithi County government. We have over 50 cases in Meru County involving allegations of embezzlement of public funds. Those cases are at different stages of investigations, and when complete, action will be taken based on the outcome of the investigations. I think that is enough for now. Not aware of such claims, and given that Eacc has a legitimate interest in every legislation, even if somebody was to sponsor a bill, so long as it's a good law for the country, we should look at the bill in terms of its merit. And the EACC, as the agency mandated to fight corruption, has analyzed that bill, has made input to the bill when it appeared before the National Assembly and the Senate. And the EACC finds that bill to be good law. That is the initial bill that was taken to the National Assembly. Before the mutilation, that was a kind of law that would address the current obstacles to an effective fight against corruption. You cannot have a situation where you, on one hand, argue that agencies are not doing their work, and on the other hand, you are taking away from them the tools that they require in order to effectively do what they are supposed to do. Recently, we advised a cabinet secretary who comes from this area not to appoint a person he intended to appoint simply because the person had integrity issues. But because the law is weak, it has gaps, he proceeded and appointed an individual with serious integrity issues to a public office. Those are the kind of things that need to be addressed by strengthening the laws. And some of the provisions in the bill that have been deleted could have seen people with outstanding issues step aside during investigations and not appointed to offices until they are cleared by agencies. So we cannot expect that law enforcement agencies will effectively do what they are supposed to do if the tools that they require, including the legal mechanisms, are removed in the manner the Senate of the Republic of Kenya proposes to do.